Sorry about that. We had the computer shut down, so I apologize for the interruption. So let's just start over. Greetings, 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 greetings. I am King Clifford Jefferson, ascendant of Godfrey, the fifth county Banju, the son of folk ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know is called the Vicar of Christ, or Melchizedek, or the King of Righteousness. It is June 12, 2026, which is equivalent to the birth year 2976. I greet you in the name of King Edgar the Peaceful. I greet you in the name of the elders. I greet you in the name of the predecessors, the successors. I greet you in the name of you. I greet you in the name of my Queen Sister Galbertson from the House of Galbertson. I greet you in the name of Archbishop Belmont from the House of Belmont, as well as my other officers, as well as those who are the free men, free women, and free children of the Rim. All right. This is very important to understand that this is part two of Who Are the Popular People. And we're going to let New Jersey's 1947 Constitution verify that. Okay. We're going to share our screen and just define again, real quick, uh, popular sovereignty as well as the people before we move on with the explanation of part one, which will be explained in this part two. Uh, 1 second. Which will be explained again. Part one will be explained in this here lecture, part two, but a little bit broader. Okay, so it's very important that you understand how important both of these lectures are in lieu of clarity. All right, of who are the popular people, and the only way you can understand that is through New Jersey's Constitution, which is the modern application of our ancient laws. Okay, our unimpaired laws or rights or privileges. Okay, unimpaired. Okay, very important to understand that term, unimpaired. All right, so with that, we get started with this marvelous lecture. Once again, write these terms down. I got all day, so if you have Wikipedia, pull it up as well for yourself and save it exactly how I'm explaining it to you. That way, you have an outline lesson plan for yourself. 1 second. What's up with mine? Hopefully, we won't have any problems with the computer today. Please, if you can, leave me a comment in the comment box. All right, as well as share this channel to others. If you got any questions, please leave them in the comment box, and I'll answer them as they come. The term "the people" refers to the public or common mass of people of a polity, which is a body of politics. As such, it is a concept of human rights laws, international law, as well as constitutional law, particularly used for claims of popular sovereignty. Okay, so it has to do with human rights laws. All right, natural philosophy, international law. Okay, this is laws dealing with rights and privileges abroad, as well as constitutional law. This is dealing with rights and privileges uh, on the soil. Okay, very important. All right, particularly used for claims of popular sovereignty. In contrast to a people, i.e., the people versus a people, is any plurality of persons considered as a whole. So that means a group of people other than a common group of people or public that denotes to those who have a ethnicity, race, or nationality versus those who are considered a people in which the nationality, ethnicity, or race does not come into question. All right. So used in contrast to the people, a people is a plurality of persons considered as a whole. Used in politics, in law, the term "a people" refers to collective or communities of a ethnic group or nation. So when you're talking about a people in contrast to the people, a people is a plurality of persons considered as a whole that may have different nationalities, okay? Might have a different ethnicity, okay? So that makes them different people within the community as a whole, okay? But we're talking about the people, all right? The people, very important. And it said particularly used for claims of popular sovereignty. So what is popular sovereignty? Let's define that term. Popular sovereignty is the principle of the leaders of a state and its government are created and sustained by the consent of its people. That's science. All right. Who are the source of all political legitimacy. Once again, popular sovereignty is the principle that the leaders or rulers of the state or of a government, all right, are created and sustained by the consent of its people, who are the source of all political legitimacy. Popular sovereignty being a principle does not imply any particular political implementation. Benjamin Franklin expressed the concept when he wrote that in free governments, the rulers are the servants and the people their superiors and sovereigns. This is where the term popular sovereignty comes in. All right, very important. Now we go to legal race theories in what we call America or the United States. Under judicial aspects of race in the United States, Write this down. Legislation, not we're not talking about the executive department nor the judicial branch. We're talking about the legislative branch, the first branch that was created in the establishment of a polity or a body of politics. Legislation seeking to direct relations between racial or ethnic groups in the United States has several historical phases. Remember, this is judicial aspects of race in the United States. Judicial, all right, aspects of race in the United States that we're reading from. Legislation seeking to direct relations between racial or ethnic groups in the United States has several historical phases. Okay, when we say historical, we mean stuff that that predated, things that happened retrospectively. Okay, development from European colonization of America, the triangular slave trade, and the American Indian Wars. All right, look at that real close. Development from the European colonization of America, that goes back to the Spanish slave trade, the discovery of North America, which were all done under the auspices of the Spanish Empire, which automatically goes into what we call the triangular slave trade on the Atlantic seacoast, which ultimately led to the American Indian Wars on this continent that we now call America or the Americas. The 1776 Declaration of Independence, once again, the 1776 Declaration of Independence included the statement that all men are created equal, which has ultimately inspired actions and legislation against slavery and racial discrimination. When we're dealing with slavery and racial discrimination, the only people that fit that capacity is the black people or those identified as the Negro. Okay? So when they was talking about all men are created equal, they were not talking about the slave, i.e. the black man or the Negro, because he was subject to the triangular slave trade as a result of the European colonization of the America. All right? Very important. Such actions have led to the passage of the 13th, the 14th, and the 15th Amendment to the Constitution of what? The United States. That's very important to understand the timeline, all right, based upon the interest and the capacity of a people, all right, that exists at this time. The first period extended until the American Civil War and the Reconstruction era. So we know at this time, the Negro or the black, and based upon their interest and capacity to whatever going on at this particular time, was unknown. Their interest and capacity was unknown until the passage of the 13th and 14th Amendment, okay? Which resulted from what? The American Civil War that happened in the time of the Reconstruction era. The second period spanned the nadir of American race relations period until the earliest 20th century. Okay? The rest of this paragraph is irrelevant except the case United States versus Bhagat Singh Ding, a case from the United States Supreme Court. That case is very important. Let's scroll down here. Until the American Civil War, slavery was legal. After the American Revolutionary War, the United States Congress passed the Naturalization Act of 1790. You hear that? Y'all not listening. Y'all is not, even though you're listening to me, you are not listening. You are not listening to what I just read. All right? If you are listening, then you're going to be able to catch what I show you next. All right? Until the American Civil War, slavery was what? Everybody said it was legal, lawful, valid, justified, recognized. All right? But after the American Revolutionary War, the United States Congress, all right, not the people, not a people. These are representatives, all right, acting in their corporate capacity, not in their private capacity. They're acting as delegates as authorized by the Constitution, okay? Very important, all right, to understand their capacity. It says the Congress passed the Naturalization Act of 1790. So they are not your, what we call, popular sovereign people, or what we call the term popular sovereignty. United States Congress is not the popular sovereignty that we just defined, okay? But yet they passed the Naturalization Act of 1790 to provide a way for foreigners to become citizens of new countries. So the Naturalization Act of 1790 provided a way for foreigners to become citizens of a new country. Y'all not listening. It limited naturalization to aliens who were free white persons and thus left out indentured servants, slaves, free African Americans, and later Asians. So the Naturalization Act of 1790 provided a way for what? Foreigners to become what? Citizens of what? A new country. It limited naturalization to aliens who were free white persons and thus left out indentured servant, slaves, free Americans, free African Americans, and later Asians. So we were not classified as naturalized aliens, okay, or foreign aliens, because a foreign alien can become a naturalized citizen. The Naturalization Act was to naturalize foreign aliens. How many of you understand that? After the Revolutionary War, most northern states abolished slavery, even if gradually. Congress enacted fugitive slave laws in 1793 and in 1850 to provide for the return of slaves who escaped from a slave state to free states or territories. Black codes were adopted by several states generally to constrain the actions and the rights of free people of color, as slaves were controlled by what? Slave laws. Although most northern states had abolished slavery, several tried to discourage freedmen from settling in the state. In some states, the black codes were incorporated into or required by state constitutions, many of which were rewritten in 1840. Very, very, very important. Let's go down here. They enacted the Naturalization Act of 1870 to allow African descent to become naturalized as United States citizens, meaning that they are now naturalized, but their prior status was a foreign alien. The purpose and intent for the Naturalization Act of 1790 and 1870 was to naturalize foreign aliens. The 14th Amendment and the 13th Amendment was not created for the purpose of naturalizing foreign aliens. It was created for those who had a relationship to the soil going all the way back to what we call jus sanguineus. Okay? Very important. It was not a part of the common law because the common law right to citizenship was based upon just soil. We find that in the Magna Carta. When we're dealing with blood, a legal fix had to be created, such as De Notis Ultimarii of 1350, which was a legal fix to include those who have a permanent domicile in the kingdom or the state or the United States or the territories or overseas territories. Okay, very important to understand that they had a permanent domicile status versus a temporary sojourner or someone who was unlawfully there. All right, which is clearly dictated by law. Okay, by law. Anti anti miscegenation laws. Miscegenation laws. If I pronounce that wrong, please forgive me. All right. Miscegenation laws. Miscegenation. That's a crazy word. Miscegenation laws. If I pronounce that right. Anti-miscegenation laws prohibited marriages of European Americans with Americans of African descent, even those of mixed race. Some states also prohibited marriages across ethnic lines with Native Americans and later Asians. Such laws had been first passed during the colonial era in several of the 13 colonies, starting with Virginia in 1691, and after the American Revolutionary War, several of the newly independent states repealed such laws. However, all slave states and many free states enforced such laws in the antebellum era. Okay? In the antebellum era. Let's go right here. Judicial aspects of race in the United States. This is what we're reading right now. Racial construction and immigration. We talked about this yesterday. In 1751, American Benjamin Franklin classified the world's population into 4 different colors. You hear that? Aberrations. Black, tawny, swarthy, and white. Franklin classified as the French, Germans, Russians, and Swedes as swarthy, as he only considered the English as white people. Very, very, very important. If he considered the English as white people, then English as white people, based upon the aberration of color of skin, based upon the purpose of the Naturalization Act of 1790, would clearly classify them as what? Foreign aliens. Okay? Foreign aliens. So that is suspect. Alright? The fact that Franklin classified as the French, Germans, Russians, and Swedes, he said that they were in fact swarthy people, but the English he classified as white people. Very, 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 very important that we take a good look at that. Okay? All right. That being said, let's go here. To observations made by Benjamin Franklin. We're going straight to the source. Why is my screen freezing? Trying to get this to come in. Bear with me. How can I refresh this? Okay. Observation concerning the increase of mankind peopling of countries. Once again, we know that when we're talking about the people, we're talking about the popular sovereigns, okay? The popular sovereigns, okay? Those who have the political power, okay? Those who have the political power. Listen very close. All right, and we're realizing what Benjamin Franklin classified different groups. He classified as the white people, all right, as the English, all right. That's what he classified. But everybody else, he classified as swarthy, all right. He classified as swarthy. What does swarthy mean? Dark, black, or swart, all right, meaning dark, black, or swart. Okay, very important to understand the term that Benjamin Franklin used to classify Europeans. Okay? Europeans. Observations concerning the increase of mankind. You heard what he said. Mankind. Not man, but mankind. Peopling of countries. ETC. They're talking about countries. Is a short essay written in 1751 by American polymath Benjamin Franklin. It was circulated by Franklin in manuscripts to his circle of friends, but in 1755 it was published as an addendum in a Boston pamphlet of another subject. It was reissued 10 times during the next 15 years. Y'all listen. We briefly touched upon this article yesterday. We're going to really clarify it broadly today. The essay examines population growth and its limits, writing as at the time a law subject of the British Crown. So Benjamin Franklin was writing as a law subject of the British Crown, not the English Crown. The British Crown and the English Crown did not unify till 1707. That was called the Great Britain, or the Kingdom of Great Britain. Prior to that, English and Scotland had different or separate parliaments, okay? Different body of politics, and the people who made them up had a different popular sovereignty, okay? Whether you're going back to the feudal era or you're dealing with a modern time, the capacity of the people are different. We know that the capacity of the delegates within the Constitution of New Jersey is different from the capacity of the people in the preamble in Article 1, okay? Very important. Their capacity and interest based upon privileges and rights is totally different. All right, let's continue. Now, he was a lower British subject, right? He was subject to the Naturalization Act of 1790, and that act was exclusively and inclusively for alien foreigners or foreign aliens, okay, who became naturalized to become a citizen of another country, but not your own. So the true status of those who were in the 13 colonies were considered alien foreigners, foreign aliens, for better word, a better way of saying it. They were foreign aliens. Franklin projected an exponential growth, doubling every 25 years in the population of the 13 colonies, so that in a century, the greatest number of Englishmen would be on this side of the water, thereby increasing the power of England. I repeat, Franklin projected the exponential growth within 25 years short of a generation, and the population of the 13 colonies, okay? Not in UK, not in Great Britain, overseas, we're talking about right here in what we now call North America. In the time of Benjamin Franklin, and he was concerned about Englishmen who will be on this side of the water, thereby increasing the power of England, i.e. the body of politics. As Englishmen, they would share the language, manners, and religion with their countrymen in England, thus extending English civilization and English rule substantially. When you're talking about substantially, we go into what we call substantial rights. Okay? Very important that you understand it from this perspective. Anti-German sentiments. While the essay was an important contribution to economic and population growth, recent attention has focused on the final two paragraphs. Franklin was alarmed by the influx of German immigrants to Pennsylvania. We're talking about Pennsylvania, we're talking about East Jersey and West Jersey. They go into what we call the Presbyterians, which were those who were subject to the body politics founded under what we call the British government, going all the way back to Charles II, which were the monarch who issued out the charters, to George Carteret and John Berkeley, which were surrendered back to the crown in 1702. The English crown, all right? But nonetheless, Benjamin Franklin goes on to state that the German immigrants, and we know that the origin of Anglo-Saxons is Germans, all right? Very important. The origin of the Anglo-Saxons, before they were unified by Alfred the Great and then be calling English, they were considered classified as Germans. Those tribes who migrated across what we call the Rhine, okay? All right, as a result of Rome's fall in England, okay? Very important, or what we call Britain. All right, so it says that the German immigrants were lacking in a liberal political tradition, the English language, and Anglo-American culture. Once again, the German immigrants were lacking in liberal political tradition, the English language, and the Anglo-American culture. The Anglo-American culture. In paragraph 20 of the essay, Franklin wrote, "Why should the Palatine Boers be suffered to swarm into our settlements, and by herding together establish their language and manners to the exclusion of ours? Why should Pennsylvanians, founded by the English, become a colony of aliens, who will shortly be so numerous as to Germanize us instead of our Anglifying them, and will never adopt our language or custom any more than they can acquire our complexion?" Listen listen to what is being said. Okay? When we're dealing with the Naturalization Act of 1790, it dealt with the aberration of a color of skin which was white, which Benjamin Franklin denoted to what? The Anglo-Saxon, which the origin of the Anglo-Saxon is German, but yet he stated that the Germans were considered Palatine Boers, which are considered rude people. All right? Very important that you comprehend your king. Schimberg finds that Franklin's main concern over the growth of the unassimilated Germans and the threat to Anglo-American culture in the English language Once again, Chabert finds that Franklin's main concern over the growth of assimilated German, what we call Palatine Boers, is the threat to Anglo-American culture and the English language. This becomes racial when Franklin concocts categories of his own invention. Franklin favored immigration of Anglo-Saxons who, according to Armand Seve, he identified as the only white people among the various people of the world. So the Anglo-Saxons Benjamin Franklin classified as white people, which is based upon the Naturalization Act of 1790, was to naturalize foreign aliens. Okay? Foreign aliens. This must be clear to you, brothers and sisters. All right? Franklin favored immigration of Anglo-Saxons who, according to Armand Seve, he identified as only white people among the various people of the world. Although such an idea would have been highly unusual at the time, and Franklin never mentioned race at all, but complexion, nor does he deny that Germans belong to what? The white race, okay, which are in fact the Anglo-Saxons who migrated into what we call Britain. Very important that you understand. And he identifies these Europeans as swarthy because he identifies the people here through the Naturalization Act of 1790, going back to the Anglo-Saxon descent. He only classified them based upon white people. I hope this makes sense to you all. All right. Let's go to the evidence. It says, page 23 of this essay. We're not going to start there. We're going to go to not page 23, point 23. But we're going to go to point 8. Remember, the Naturalization Act of 1790 was for foreign aliens. Okay? For foreign aliens. This must be clearly understood. So, based upon that understanding, the white people are foreign aliens. The only way they become citizens is through naturalization, in which the people who came through the 14th Amendment does not fit that classification based upon the capacity. Because our capacity was based upon our permanent domicile going back to our parents. Okay? Very important. Come on. Bear with me. I'm trying to get this article to come up. Come on. won't pull up. What's up? Refresh. Let's see if this helps. No. Something wrong with that platform. Let's see if we can pull it up from somewhere else. This article does not want to come up. Why is that? They don't want me to tell you the truth. But I got something better. Remember, Benjamin Franklin was the loyal subject of the British Crown. Okay? Congress passed the Naturalization Act of 1790 to naturalize foreign aliens. Okay? That point, specific point, cannot be overlooked. Now, where was I going to? Oh, right here. Is this it? That's not it. 6. Is this it? Nope, that's not it. Okay, I don't know why it's not letting me bring up this article from Benjamin Franklin from the actual website. Let's try it one more time from archives. I don't know why it will not open up. Refresh. If it doesn't open up this time, we're going to move forward. It's not coming in, so we're just going to bypass that. Let's move to alien law. right? Alien. In law, an alien is a foreign-born resident who has not been naturalized and is still a citizen or subject of a foreign country, although definition and terminology different across the legal systems. Once again, in law, an alien is a foreign-born resident who has not been naturalized and is still a citizen or subject of a foreign country, although definition and terminology differ across legal systems. This is very, very, very important for us to understand that. The term alien is derived from the Latin alienus. The Latin later came to mean a stranger or a foreigner or someone not related by what? Blood. Okay? When we think about the Naturalization Act of 1790, they didn't classify themselves as swarthy. They classified themselves as white because they were not of the blood of the swarthy people. Okay, that's very important to understand that. But nonetheless, they wanted the rights of the swarthy people because in Ray Hassan it said the apparition of those Anglo-Saxon was not white. How Benjamin Franklin uh, 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 classified them. Okay, very, 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 very important for you to understand that. So the categories in regards to aliens, all right, different categories around the world use various terms for foreign nationals, also called non-citizens. So that means that a foreign national is a non-citizen, okay? And even if you were naturalized, you still consider a non-citizen because the Constitution nowhere defines citizen. All right, we see that argument made in Wang Kim Art. Those who have relinquished their citizenship in or nationality may or not be an alien in the host country. You hear that? The host country. The followings are general categories. Permanent resident, any immigrant who has been lawfully admitted into a nation and granted the legal right to remain there and as a permanent resident, including registered refugees, in accord with the nation's immigration law. Then you have temporary residents. Any foreign national who has been lawfully granted permission by the government to drive, fly, travel, lodge, reside, study, or work for a specific number of years and then apply for an extension or leave the country before such permission expires. Very, very, very important. Then you have non-resident aliens, any foreign national such as a travel visa holder or a foreign tourist is lawfully within a nation, but whose legal domicile is in another nation. So when you go back to the Constitution, all right, in regards to what we say the people are what we call the popular sovereigns, then they are in fact the citizens. But the Constitution does not say that these people are in fact identified as citizens because the common law says the determination must be sought elsewhere. Okay? Alien enemy or enemy alien, any foreign national of any country that is at war with the host country. That's Title 8 United States Code 1442. In regards to those who become naturalized, that's Title 8 United States Code 1422. Okay, for those who have a permanent domicile, that's United States Code Title 8 1401. Okay, very, very important for you to comprehend that. Why? Because of this. New Jersey's Constitution. Right there in the preamble, very important. pull that up. Okay, remember what Benjamin Franklin said. Let's go back to it before we go into the Constitution. All right. All right. Very important. Two sources. All right. This is judicial aspects of race in the United States on Wikipedia. It says right here, until the American Civil War, slavery was legal. After the American Revolutionary War, the United States Congress passed the Naturalization Act of 1790 to provide a way for foreigners to become citizens of a new country. It limited naturalization to aliens who were free white persons and thus left out indentured slaves, free African Americans, and later Asians. Very important. You see the same language in the observation made by him. Let's read this one again. Observation concerning the increase of mankind peopling of countries. It is a short essay written in 1751 by American polymath Benjamin Franklin. It was circulated by Franklin in a manuscript to his circle of friends, but in 1755 was published as an addendum and a Boston pamphlet on another subject. It was reissued 10 times during the next 15 years. The essay examines population growth and its limits, writing as, at the time, a lower subject of the British Crown. Franklin argues that the British should increase their population and power by expanding across the Americas, taking the view that Europe is too crowded. Okay? Once again, it didn't say English. It's the essay examines the population growth and its limits, writing as, at the time, a lower subject of the British Crown, not a lower subject of the English Crown, but a lower subject of the British Crown. Franklin argues that the British, not the English, but the British should increase their population and power by expanding across the Americas, taking the view that Europe is too crowded. This goes back into what he stated about the what? The German Boers. Okay? The German Boers. We're going to talk about that in 1 second. All right? And we're talking about German Boers. We know the word Boers means those who are rude people. All right? Franklin argues that the British should increase their population and power by expanding across the Americas, taking the view that Europe is too crowded. All right? I didn't say that. He said that. In the population of the 13 colonies, all right, so that in a century the greatest number of Englishmen will be on this side of the water, thereby increasing the power of England. You just got finished talking about British people, not English people. You just got finished talking about British people, because you said you were a British subject. You didn't say you were an English subject. You were a British subject. Why? Because both of your capacity was based upon foreign aliens. Okay, foreign aliens. You didn't have the blood. Okay. We see that in Calvin's case, and that was the reason why the Nuntius Ultima of 1350 was enacted, okay? Such in the case as it is being called upon in the present day, all right? So that in a century, the greatest number of Englishmen will be on this side of the water, thereby increasing the power of England. As Englishmen, they would share language, manners, and religion. You hear that? Language, manners, and religion with their countrymen in England. These are rights and privileges that are not enumerated, may not be enumerated in your Constitution. Okay? So these rights are considered retained rights, all right, versus rights that were given to you that you previously didn't have. All right? As Englishmen, you had a retained right. And a retained right is a right that was not actually enumerated in the present implication of rights that they saw fit that you needed. Okay? So these are enumerated right versus non-enumerated right. And the Englishman had non-enumerated rights because the rights they had were unimpaired rights. Okay? In which the Constitution cannot impair those rights that were there from generations to before and generations to come. So the population of the 13 colonies, so that in a century the greatest number of Englishmen would be on this side, not that side, but this side of the water. This is called littoral rights, thereby increasing the power of England. As Englishmen, they would share the language, manners, and religion with their countrymen in England, thus extending English civilization and English rule substantially. This goes back into Article 1 of the Magna Carta. All right? Not just members of the clergy, not just officers, barons, knights, etc., but as well as the freemen of the realm, which had the ability to preserve their unwritten privileges and immunities from through perpetuity. Okay? Very important. Franklin viewed the land in America as underutilized and available for the expansion of farming. This enabled the population to establish households at an early age and support large families than was possible in Europe. The limit to expansion reached in Europe, but not America, is reached when the crowding and interfering with each other means of the substance and the idea would inspire. Malthus. Anti-German sentiments. While the essay was an important contribution to economic and population growth, recent attention has focused on the final paragraph. Franklin was alarmed by the influx of German immigrants to Pennsylvania. The German immigrants were lacking in a liberal political tradition. Okay? These are retained rights that were unimpaired, that was there generations before these English people came, or people who claim to be English came upon the scene. Okay? This is an inherited right, a natural and inalienable right that's preserved in our present and modern day Constitution. Okay? Why? Because it's written in what? The English language. All right? It's written in the English language, not the German language, not the Dutch language, not the Swedish language, but the Anglo-American language, because the English is the Anglo-American culture. In paragraph 23 of the essay, which I couldn't pull up as a result of some type of technical difficulties, Franklin wrote, "Why should the Palatine Boers be suffered to swarm into our settlement, and by herding together establishing their languages and manners to the exclusion of ours?" This is so important when you're talking about the Palatine Boers. Why should Pennsylvania, founded by the English, so it said Pennsylvania was founded by the English, but yet the so-called or some English gave charges to the so-called Germans or the Palatine or the Boers, which goes back into what we call the Puritans. All right. Why should Pennsylvania? We know Pennsylvania was founded by who? William Penn. Why should Pennsylvania, founded by the English, become a colony of aliens who will shortly be so numerous as to Germanize us instead of our Anglifying them, and will never adopt our language or custom any more than they can acquire our complexion? Schönberg finds that Franklin's main concern over the growth of unassimilated Germans is the threat to the Anglo-American culture in the English language. Okay? American and Anglo are two different, distinct people. Okay? Yet they are within the same boundaries as a result of stories of assumed or claimed immigration by people who actually didn't immigrate here, but they were in fact indigenous, which goes back to their identity as English people. All right. This becomes a ratio when Franklin concocts categories of his own invention, and this was a result of what? Germans. All right, Germans. This becomes a ratio when Franklin concocts categories of his own invention. Franklin favored immigration of Anglo-Saxon, who, according to Armand Seve, has identified as the only white people among the various people of the world. Okay? And the white people were those who were naturalized under the Naturalization Act of 1790, which clearly points to the fact that they were what? Foreign aliens, which are what? Non-citizens. Okay? Franklin favored immigration of Anglo-Saxons. Who are Anglo-Saxons? Anglo-Americans are a demographic group. Let's go here. See, now you hit Anglo-Saxon, they want to pull up Anglo-American. That's not the case. Okay? That's not the case. Anglo-Saxon and Anglo-American are not the same, brothers and sisters. They are not the same. Let's look at this. Prove it. Rights, English nationality. English nationality or English national identity. According to some scholars, a national identity of the English as the people or ethnic group dominant in England can be traced to the Anglo-Saxon period. So what is Benjamin Franklin talking about in regards to they being identified as white people? Okay? Because the Anglo-Saxons are considered Europeans. All right? And they were, if according to the classification made by Benjamin Franklin, would be identified as swarthy people. Okay? All right? Ecclesiastical history of the English people in the construction of the Ophir Dyke demonstrate early English identity as early as 731 A.D. And the unification of the Kingdom of England in the 9th and 10th century established it as a national identity. They make the argument that after the Norman conquest in the 13th century and possibly earlier, this identity was codified into law when Anglo-Saxons were given second-class citizens status as Englishry. Similarly, Adrian Hastings considers England to be the oldest example of a mature nation and links the development of the nationhood to the Christian church and spread of written popular language to the existing group. Let's go right here. English identity emerged from the Anglo-Saxon period after the fall of Roman Britain, when the unification of various kingdoms under figures like Alfred the Great in the 9th century. The Norman conquest in 1066 layered Norman influence onto this Germanic base, shaping the language, governance, and culture. So we see that from Alfred the Great's unification from those tribes known as Mercia, Wessex, Northumbria, etc. All right, these became unified tribes of clans into one unified nation or ethnicity of people. Okay, and they were governed centuries later by laws governed under what we call the Magna Carta, which we talked about in our prior lessons. Okay, very, 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 very important for you to understand that. So it's talked about the Palatine Boers. Didn't it say that? The Palatine Boers. I didn't say that. They said that. That's what Benjamin Franklin said in his observation. Okay? That's what he said. Where's the word? Palatine Boers were suffered to swarm into our settlement by herding together, establishing their language in the manners to the exclusion of ours. Okay? It's right there. Everybody see that? All right? So if that is in fact the case, we know aliens or foreign aliens are those who fall under what we call the Naturalization Act of 1790. That was the purpose and intent of that act passed by what we call Congress. Okay? Passed by Congress. This is very, very important because we're going back into the Palatine Boers. This goes into what we call Sophia. Okay? Sophia of Handover. How many of you know of Sophia of Handover? Now I can go historical to back it up. Sophia of Handover, from the house of Handover, born Princess Sophia of what? Palatinate. Okay? Very important you understand that the very people that Benjamin Franklin is talking about are descendants from the house of Stuart. Okay? Very important. From the House of Stuart. Let's break this down. Sophia Andover was the Electress of Hanover from 1692 to 1698 as the consort of Prince Elector Ernest Augustus. She was later the heiress presumptive to the thrones of England, later Great Britain, following the Acts of Union with Scotland in 1707, and in Ireland under the Act of Settlement of 1701, as she was the granddaughter of King James VI of Scotland and is soon to be the first king of England because he married Margaret of Tudor from the, from the House of Tudors. Sophia died less than 2 months before she would have become Queen of Great Britain and Ireland. Consequently, her son George I succeeded her first cousin once removed, Queen Anne of Great Britain, to the British throne. The succession to the throne has since been composed entirely of and legally defined as Sophia's legitimate Protestant descendants. You hear that? This is a result of Sophia's Naturalization Act of 1705. Yes, Sophia Naturalization Act of 1705. What is that? How many of you know about that? Because it had to do everything about what Benjamin Franklin was talking about, the settlement of the Palatine Boers. Sophia Naturalization Act of 1705 was an act of the Parliament of England in 1705. It followed the Act of Settlement of 1701, whereby Dowager Electress Sophia of Hanover and her Protestant descendants were declared to be in the line of succession to the throne of her son King George, who later would become what? The King of England. Okay? This is the House of Hanover, which goes back to the Palatine Boers, which were those who spoke a different language than English. Okay? I didn't say that. Benjamin Franklin. This goes all the way back to the Act of Settlement as a result of Sophia Naturalization Act, which was a result of her succession to the throne, which goes back to the Settlement Act of 1701. Let's look at that. The Act of Settlement of 1701. Write that down. Before we go into the New Jersey Constitution. The Act of Settlement is an act of the Parliament of England, passed in 1701. This is when Queen Anne is on the throne, and the throne of England, and we know the throne is not an actual throne, it is an office or a capacity, okay, that's situated right here in Burlington or Perth Amboy, which were an itinerant court where the body politics sat, okay, the popular sovereign, okay. Act of Settlement, a Parliament Act that settled the succession to what? The English and the Irish crown to Sophia of Hanover, the daughter of Elizabeth of Stuart, the granddaughter of who? Or the daughter of King James VI of Scotland. He didn't become Queen of England until he married Margaret of Tudor, and she's from the House of Tudor. So the Act of Settlement was to settle who would succeed to the English crown, and which were passed to Sophia of Hanover, which were then passed it on to what? To who? King George I. All right? Very important. The very Palatine Boers that Benjamin Franklin was talking about. Okay? Very, very, very important. As a result of this Act of Settlement, Scotland passed the Act of Security, because it was not agreed upon by the Parliament of Scotland to pass such an Act of Settlement. Let's read it for ourselves. Now remember, Sophia passed the Naturalization Act of 1705. And we know a Naturalization Act is to make foreign nationals or parts of foreign aliens citizens. Okay? The process of naturalization is to make foreign aliens citizens. The Act of Security of 1704, which resulted from the Act of Settlement of 1701, was a result of Sophia and the elections of Palatine, which was making her in the group called the Palatine Boers. All right, she passed an act of she um, uh, was the one. Sophia was the one to succeed to the throne of England so that King George I would become her successor. All right, this was the whole plan. The Act of Security was an act for security of the kingdom, which was a response to the Parliament of Scotland to the Parliament of England Act of Settlement of 1701. Queen Anne's last surviving child, William Duke of Gloucester, had died in 1700, and both parliaments needed to find a Protestant successor. The English Parliament had settled on the elections of Sophia of Hanover, granddaughter of King James VI of Scotland and the first King of England, because he married Margaret of Tudor, without consulting the Scottish Parliament. As a result of that, of not consulting the Scottish Parliament, the Act of Security was passed, and which was a result of the Act of Settlement of 1701 passed by the Parliament of England, which was under the authority of de facto monarchs. Okay, very important that we understand that. And as a result of the Act of Security, Queen Anne passed the Alien Act. How many of you know what the Alien Act is? The Alien Act of 1705 was an act of a parliament as a response to the Parliament of Scotland's Act of Security of 1704, which in turn was partially a response to the English Act of 1701, all going all the way back to Sophia of Hanover, the granddaughter of King James VI of Scotland, whose grandmother was Elizabeth of Stuart, okay, the daughter of King James VI of Scotland. All right, the Alien Act of 1705, we know an alien is a foreign alien which goes through a naturalization process, and which is what we're talking about right now. The Lord High Treasurer was instrumental in the Union of 1707 and all the acts leading up to it. The act was passed to prevent the inconveniences that would occur hastily if these two kingdoms were not to become one union. What union? The unification, what we call the Union of the Crowns in 1707. The act provided that the Scottish nationals in England were to be treated as what? Alien foreign nationals. Once again, alien foreign nationals. And estates held by Scots will be treated as alien property, making inheritance much less certain. It also included an embargo on the import of Scottish product into England and in the English colonies. Did you hear that? Did you hear that? Now, considering what Benjamin Franklin said in regards to judicial aspects of race in countries, as well as the what was it called? The observation concerning the increase of mankind, people in countries. He clearly points to these people that we're talking about right now, which were the Palatine descendants, which were, according to this act, foreign nationals. Okay? Foreign nationals. You can't make this stuff up. Okay? You can't make it up. So that takes us right back here to the Constitution. Let's go to the Constitution, brothers and sisters. Okay. Rights and privileges. Listen to what's being said. Okay. Declaratory injunctive relief. Okay, is what we request in regards to due process of law, which is an inherited right. Okay, from God, not from the delegates who represent the government, which were put there by us, based upon us as a popular sovereign people. Okay, I didn't say that. Benjamin Franklin said it. It said Constitution was agreed upon by the delegates of the people of New Jersey in convention, which began in Rutgers University, the State University of New Jersey and New Brunswick, on the 12th day of June and continued to the 10th day of September in the year of our Lord 1947. Not in the year of a man, but in the year of a Lord. Now, who was that Lord is yet to be understood. It says here, we the people, listen to the language of what you're reading. All right? The plain language, in lieu of declaratory injunctive relief that we request, all right, not reparation. We want declaratory and injunctive relief based upon the acts of this of whoever it is that are violating our rights or due process rights. All right, we have the right to what we call what we call a writ of mandamus, which is an order to show cause. All right, it says we the people of the state of New Jersey, we the people, the popular sovereigns, grateful to Almighty God, not to the delegates, but to Almighty God for the civil and religious liberties. So you don't just have religious liberties, you have civil liberties, okay? Which has so long permitted us to enjoy. Not the enjoyment didn't come from the delegates, it didn't come from the representatives of the government, it came from God, okay? Your civil and religious liberty came from God. God is not affiliated with a secular government or humans. God is affiliated with spirituality or religious theosophical principles, which are related to ecclesiastical or canon law, i.e., the church. So when we look to our preservation of our inheritance as promised by God in lieu of Leviticus 25:10, all right, return to our family, return to our clans, return to our property, to return to our inheritance. We don't look to man, we look to God. And God has have put within his word, in the beginning with the word was God, and the word became flesh and dwelt amongst man. What man? These delegates, okay? A kind of man, mankind. We the people of the state of New Jersey, grateful to Almighty God for the civil and religious liberties which has so long permitted us to enjoy. So Almighty God had permitted us to enjoy our civil and religious liberties before the enumeration of these civil and religious liberties that are enumerated right here, that we're reading right here on the face of this Constitution. Okay? We already had these religious and civil liberties that were unwritten. Okay? We retained these rights. Where did they go? They were reserved for the people. We, the people of the state of New Jersey, grateful to Almighty God for the civil and religious liberties which has so long permitted us to enjoy, and look unto Him, for a blessing upon our endeavors to secure and transmit the same unimpaired to succeeding generations through ordain and establish this Constitution. So the delegates didn't ordain this Constitution. We, the people, ordained this Constitution for the perpetuity of our civil and religious liberties in lieu of the endeavors that were preserved, i.e., that we retained from generations that preceded us and to generations that would succeed us. Okay, very important. We had these rights, we had these immunities, we had these privileges, but as a people, what people we have yet to understand. Article 1, rights and privileges. We know where our civil and religious liberties come from. It was right there in the preamble. Right there. Right there being exemplified in secular law. This is the Constitution of New Jersey in 1947 that has the capacity in regard to the interests that's preserved in lieu of the rights and privileges that's preserved in the preamble for us for generations to come. Not that just has passed, but to come. These are retained rights that are unimpaired. All right? Meaning that these enumerated rights that we're reading right now cannot impair the unimpaired rights that we had prior to that we had generations in the past. Okay? Because they came from God. Rights and privileges. All persons are by nature free and independent and have certain natural and unalienable rights, among which are those of enjoying, defending life, liberty, of acquiring, possessing, and protecting property, and of pursuing and obtaining safety and happiness. This is Article 1 of what? The Magna Carta, Clause 1. That's Clause 1 right there you're reading. Clause 1. The Magna Carta was embedded in the 14th Amendment, and the 14th Amendment was embedded into New Jersey Constitution, Article 1, Section 1. All right? Right there, let's read it for ourselves. Because we know that the preamble involves God. We know God is the father of the church, okay? Which is the purpose of separation of church and state. On the federal level, it's called the First Amendment, and we know the Fifth Amendment is a due process clause, okay? And know the 14th Amendment is our citizenship clause. We know that all that was incorporated in New Jersey's Constitution under Article 1, all right, which goes back to the capacity that we had that was unimpaired and we retained by an unwritten law, which goes back to our customs and traditions that we see in what we call the Magna Carta. Let's pull it up. Let me find a better one. This right here is the preamble in the First Amendment, all right, that you see in New Jersey's 1947 Constitution, all right. We see that this capacity and interest that we see in New Jersey's Constitution, the preamble in Article 1, Section 1, okay, which involves Section 2 and Section 3 of New Jersey's Constitution. We know that prior to New Jersey's 1947 Constitution, this capacity was not there. This capacity was not there, okay? We understand that the 14th Amendment preserved our capacity that was hidden from us because we did not know who we were as a people, okay? The popular sovereigns, okay? It says here, first, that we have granted to God pretty much the same language of the preamble of New Jersey's 1947 Constitution in regards to religious privileges and liberties. And by this present charter have confirmed for us and our heirs in perpetuity, us and our heirs. You talk about corporate capacity and private capacity, still affiliated with what? The church. Okay? Still affiliated with the church. The rights of the church and its members in lieu of our corporate and private capacity is protected by what? The 14th Amendment, New Jersey Constitution, Article 1, Article 2, Article 3, and preserved by parts of now Article 1, Article 2, Article 3, Section 1, Section 2, Section 3, and Section 21. It says, first that we grant to God, and by the present charter have confirmed to us and our heirs in perpetuity. This is for generation and generation and generations to come. All right? Same language we see in New Jersey's Constitution of 1947. Generation and generation and generations to come. After the 1947 Constitution embedded or enumerated these rights and privileges that we now have, which are not the rights that we retain, that were unimpaired, because why? They were not written down. Okay? Very important. And by the present charter we have confirmed to us and our heirs in perpetuity that the English church should be free. Whether you say church, all right, whether you say monastery, nonetheless, it is the English church should be free. Okay? It ain't talking about the church, because the church is made up of the people. Without the people, what be the purpose of the church? All right? And shall have its rights, undiminished, and its liberties, what? Unimpaired. You hear that? Unimpaired. Keyword. We know when we impair something, then it means to tamper with it, damage it. All right? We know when we say unimpaired, meaning that it's left alone. Okay? So it says that the religious rights that we have, that we see in Clause 1 of the Magna Carta, which we know is the supreme law of the land, all right? It says the rights and liberties are unimpaired for our religious society, which we call the English Church, which is now called the Third Temple English Church in England, based upon our corporate capacity as members. No matter what we identify those members as, we still have that corporate capacity of the religious society, which we call the English Church in modern day. Not just in our corporate capacity, but in our private capacity as free men, because it also goes on to say that this freedom we should observe ourselves and desire it to be observed in good faith by our heirs in perpetuity. And to all free men of our kingdom, we have also granted for us and our heirs forever all the liberties written out below, to have and to keep for them and their heirs of us, to keep for their heirs of us and our heirs. So it's telling you that we not only have unimpaired rights, all right, we also have rights that were what they just said, rights that were written down. Okay, when we have laws that are written down, these are laws that what we call enumerated or created, versus the laws that are not written down or laws that are not created, but laws that we did have prior to us coming into that understanding. Okay, these are unwritten liberties and privileges. All right, very important to all free men in their private capacity and not their corporate capacity. How many of you understand that? We're covering a lot today. All right, let's get it. So that is the Magna Carta, and it specifically says, shall have their rights undiminished and liberties unimpaired. All right? Liberties unimpaired. Let's go back to the Constitution of New Jersey. Article 1, rights and privileges. Okay, not for the delegates, they're trustees. All right? They're not the popular sovereigns. We are. Okay? It's right there in the law. All persons are by nature free and independent and have certain natural and unalienable rights. This is called natural philosophy. Okay? Conscience. Among which are those of enjoying and defending life and liberty. This is due process of a law. And acquiring and possessing and protecting property and pursuing and obtaining safety and happiness. This is very, 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 very important. The same capacity we had under the English Church in the 13th century, we now have at the Third Temple English Church of England, because we have incorporated that capacity, okay, which is protected by Article 1, Section 1, which deal with rights and privileges granted by God and not the delegates, okay? Very important. Then we have 2, the origin of this sovereign inherited interest that we have and the capacity granted to us through our inheritance as God's children. Okay? It says all political power is inherited in the people. The popular sovereigns, the people. Not a people, but the people. Government is instituted for the protection, security, and benefit of the people, just like we read in the preamble. And they have the right at all times to alter or reform the same whenever the public may require it. 3. No person should be deprived of the estimable privilege of worshiping Almighty God in a manner agreeable to the dictates of his own conscience. So if our conscience is not dictated based upon Section 1 of the Constitution, we are in violation of our own law, because the popular sovereignty to exercise such a right was embedded in Article 1. All right? They didn't put that there. We put this there. This was a retained right that they cannot impair. Okay? Because it wasn't granted by them. It was granted by who? Almighty God. Nor under any pretense whatsoever be compelled to attend any place of worship contrary to his faith and judgment. Nor should any person be obliged to pay tithes, taxes, or other rates for buildings or repairing of any church or churches, places of worship, or for the maintenance of any minister or ministry contrary to what he believes to be right or has the liberty and voluntarily engaged to perform. Okay? Very important. Section 1, Section 2, Section 3, and we're going to do in Section 7. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures should not be violated, and no warrant shall issue except upon what? Probable cause, in order to show cause. This is what we call right of inquest, which is what we know as a writ, supported by oath and affirmation, particularly describing the place to be searched and the papers and things to be seized. All right? All of this is protected by Section 21 of New Jersey's Constitution. Let's look at it. Section 21 of Article 1 of New Jersey's 1947 Constitution and Section 21 of Article 1 of New Jersey Constitution protects Section 1, Section 2, Section 3, and Section 7 of Article 1 Constitution, all relating to your inherited, natural, and inalienable rights given to you by God, all right, that was preserved from generations before you even got here, all right? Very important. How we know it? Let's read it right here. Section 21. This enumeration of rights that you read from Article 1, from Section 1 to Section 21, all right? These are the enumeration of rights and privileges that should not be construed to impair or deny others retained by who? The people. The same people that were here before they created the Constitution of 1947. Okay? So the people that exist in 1947 have rights and privileges that exist besides the enumeration of the rights and privileges that we see here in New Jersey's 1947 Constitution, and that they cannot impair those unimpairable rights that were declared not just in Section 21 of Article 1 of the New Jersey Constitution, but all the way back to the Magna Carta, because it mentioned unimpaired. It mentioned in the Magna Carta that the rights of the English church and the freemen should be unimpaired for generations and generations and generations. Okay? We must understand how important it is this lesson is. But it's going to go right over the people's head. Right over it. So this enumeration of rights and privileges should not be construed to impair or deny others retained by the people. What rights retained by the people that the enumeration of these rights cannot impair? When we say these rights, we're talking about these written laws right now. Article 1, Clause Section 1 to Section 21 are the enumerated rights and privileges that we have, but we also have retained rights that were not written down, which are not listed in this Constitution of 1947. So where are those rights at that are not listed here in the 1947 New Jersey's 1947 Constitution? We find that in what? The preamble. We the people of the state of New Jersey, grateful to Almighty God for the civil and religious liberties which has so long permitted us to enjoy, looking to Him for a blessing upon our endeavors to secure and transmit the same unimpaired to succeeding generations through ordained and established this Constitution. Who is that He are we talking about? Guess who he is? That's John, who signed the Magna Carta, because in Article 1, Section 1, and Article 1, Clause 1, parts of Clause 1 of the Magna Carta, we see the very same language. Let's go to it. First, that we have granted to God, and by this present charter, have confirmed for us and our heirs in perpetuity. Perpetuity means forever. Okay? Perpetuity means from generation and generation thereafter. Okay? So that charter confirmed that us and their heirs, successors, in perpetuity, that the English church shall be free, meaning that those heirs and successors were members of what? The English church, and shall have their rights undiminished and their liberties unimpaired. That's the same language you find in the preamble and the same language you found in Section 1, Section 2, and Section 3 of New Jersey's Constitution, and preserved by Section 21 of New Jersey's Constitution of 1947. That we wish, and we know who wished that, John, we wish this so to be observed appears from the fact that of our own free will, before the outbreak of the present dispute between us and our brethren, we granted and confirmed by the charter freedom of the church elections, a right reckoning to be of the greatest necessity and importance to it, and caused this to be confirmed by Pope Innocent III. This freedom we shall observe ourselves and desire to observe in good faith by our heirs and what? Perpetuity, that means from generation and generations to come. And to all free men of our kingdom, we're talking about at that time, we also have granted for us and our heirs forever all the liberties that were written down at that time, written down out below, to have and to keep for them and their heirs of us and our heirs. And these are the same rights that we retain in the present day, that they cannot impair based upon Section 21 in lieu of Section 1 and 2 and 3 of New Jersey Constitution. Why? Because we declared it in our preamble. How many of you understand that? How many? So in closing, like, share, subscribe. The New Jersey Supreme Court has historically recognized that the state's common law and constitutional rights are direct descendants of these precise English liberties. The clause match up with specific articles of the 1947 New Jersey Constitution. Magna Carta Clause 1 and New Jersey Constitution Article 1, Paragraph 3 and 5, or 1 through 5, deal with religious freedom and franchise immunities. Okay? The Magna Carta says that the English church should be free and should have her whole rights and her liberties inviolable. This originally established that the crown or the state cannot dismantle or absorb the property internal governance of the independent corporate religious body, how it's being conveyed to in modern day, and that's through 16:1-28. That's the proper capacity in lieu of the interest that runs with the inherited right, going all the way back to what's protected by Article 1, Section 1, Section 2, and Section 3, and Section 21 of New Jersey's Constitution. Okay? And that constitutional protection is supported by statutory law, okay, in lieu of what we call declaratory injunctive relief, okay, through statutory analysis of the plain language of the text. That's called the plain meaning rule or the golden rule. Write that down. So the Magna Carta Article 1, Article 1 says that the English church should be free and have their privileges and immunities unimpaired, as well as the freemen of the kingdom to have their rights to the written down laws that were created at that time, okay, which were to continue for succeeding generations, okay, which will be present in modern day based upon the language of the 1947 Constitution. We see here in the 1947 Constitution of New Jersey matches perfectly with Article 1, Paragraph 3 and 5, which is the same language we see in the Magna Carta Clause 1 dealing with the English church. We see Article 1, Paragraph 3 and 5 mandates that no person should be deprived of their inalienable rights and ensure absolute freedom of conscience and religious capacity. Okay? Capacity related to what? The church. Okay? Okay, so where's the hook to the conveyance or the conceding to that capacity from religious to modern day or secular law? Where's the hook? We see this bedrock hook in New Jersey by statute 16:1-28. The 1947 Constitution explicitly guarantees that pre-existing institutional liberties are protected from state subversion. Okay? 61-28 says, right state under charge of Great Britain, save from repeal an act to incorporate trustee of religious society for property held in corporations in place thereof. This is a corporate capacity outside of private capacity, which is protected by the 14th Amendment as well as the Constitution of New Jersey, since we're in New Jersey, in lieu of Article 1, Article 1, Section 1, Section 2, Section 3, and Section 21. Okay? Very important that you comprehend that. Why? Because it deals with the right to a proper remedial writ. Okay? The Magna Carta text in section clause 31 says the writ of inquisition of life or limb should be given gratis and not denied. This guarantees that citizens could force the sovereign to come to court to justify any administrative penalties or land restrictions that are imposed upon them as a result of the regulatory power that they claim to have an interest in and capacity under whatever authority gave it to them. Okay, and this case will be Title 20 of New Jersey Revised Statute or Title 5 of the federal law, which goes into what we call the eminent domain power, which deals with what their claim of popular sovereignty come from. Okay, very, very, very important. The Magna Carta text, the writ of inquisition of life and limb shall be given gratis and not denied. It's guaranteed that citizens can force the sovereign, and we know that in modern day now it's called the state, to come to the court to justify administrative penalties or land restrictions. The 1947 Constitution of New Jersey matches perfectly with Article 1, Paragraph 10, which guarantees privileges of a writ of habeas corpus and access to the courts. More importantly, Article 6, Section 5, Paragraph 4, which explicitly preserves the action in lieu of what we call prerogative writs. Okay? Prerogative writs. This is procedurally carried out through Rule 4, 69, which is the review in the Superior Court matters that result in ultra-virus acts, which are things that result in overreach, which is called ultra-virus. So the capacity in regards to prerogative writs, which we call under Queen Praetorius, which its companion is writ of mandamus, orders to show cause. This is the capacity hook that grants an individual or corporate head the absolute right to sue the state directly under New Jersey Revised Statute 4:69 to review and overturn any overreach regulatory under ultra-virus acts, which means that you had no authority to do such a thing. Okay? Then we have Magna Carta Clause 39, which is the due process clause, which we call the supreme law of the land. The same verbiage we see in Article 1, Section 1 of New Jersey's Constitution. Okay? Article 1, Paragraph 1 of which is Clause 39 of the Magna Carta, and we know that the Magna Carta, Clause 39 says that no free man shall be seized or imprisoned or stripped of his right or possession except by the lawful judgment of an equal or by the supreme law of the land. That would be your Constitution, as well as it being done by what we call a trial by jury. Okay? A trial by jury. The 1947 Constitution of New Jersey matches perfectly with Article 1, Paragraph 1, which establishes that all persons have an inalienable rights, which include acquiring, possessing, and protecting property. Okay? This is what you call your political standing. This is what you call your capacity, okay, to sue and be sued as natural people. Where's the capacity hook? New Jersey's Constitution notably does not use the exact phrase due process of law. Instead, New Jersey Supreme Court has repeatedly ruled that under Article 1, Paragraph 1, and New Jersey due process law of the land is equivalent. Once again, Article 1, Paragraph 1, and New Jersey's due process and law of the land is equivalent. Under this article, the state is prohibited from using modern administrative tactics like Title 52 or a standard condemnation statute like Title 20 eminent domain to seize possession or bypass established vested capacity without passing strict constitutional muster under ultra-virus acts in regards to statutory review in lieu of declaratory and injunctive relief. Okay? Relief. This brings me here. As we see, Article 1 of New Jersey Constitution, and this section, Section 1, Section 2, and Section 3, as well as Section 21 of the New Jersey Constitution, involves questions presented, which is what is the question? What role does Article 1, Section 21 play in relation to Section 1, Section 2, and Section 3 of the New Jersey Constitution? That's a question that you all must ask yourself in regards to your rights as a people, your rights as the popular people as established in the Constitution, Section 2. Argument, point 1. Section 1, 2, and 3 establish the primary substantive liberties. You hear that? Substantive liberties, which is called substantive rights, which are God-given rights and inalienable rights that the delegates, representatives, trustees did not give to you. Section 1 declares that natural and inalienable rights are preserved. Why? Because you retained them prior to you even being born. Section 2 declares that the political power originates in the people and that the government that the people created is there to protect that natural and inalienable right. Okay? Then you have Section 3, protects freedom of conscience and religious liberties. Together, these provisions form the constitutional foundation of personal liberties, political sovereignty, and freedom of belief. Freedom of belief, i.e., person. What's it called? Personal. What was it called? Popular sovereignty. Okay. Together, these provisions form the constitutional foundation of personal liberty, political sovereignty, and freedom of belief. I just said it. Popular sovereignty. Point 2. Section 21 functions as a constitutional rule of construction. Section 21 does not create the rights that we see enumerated in Section 1, Section 2, and Section 3 of New Jersey's 1947 Constitution. Rather, Section 21 of New Jersey Constitution instructs courts that the enumeration of the rights elsewhere, meaning that those that were not listed from Section 1 to 21 in that 1947 Constitution, all right, those that were not exclusively and inclusively listed elsewhere in the Constitution should not be interpreted to deny or disparage other rights that they already retained by the people in lieu of those inherited rights that goes back to those unimpaired rights given from God. Okay? Thus, Section 21 prevents the Constitution from being treated as a closed catalog of unlisted liberties. Point 3. Section 21 protects the principle of retained rights. I repeat, Section 21 protects the principle of retained rights. What are the retained rights? Rights that you had prior to the creation of rights that they claim you now have. Okay? So the word retained is significant. A right cannot be retained unless it existed prior to the government framework recognizing it. You hear that? Therefore, Section 21 reflects the natural right philosophy underlying the Declaration of Independence, New Jersey's Constitution, and the broader Anglo-American constitutional tradition that Benjamin Franklin was trying to preserve for themselves, even though they were not English nationals. Okay? Under this theory, government does not create fundamental rights. Government recognizes and protect rights already possessed or retained by the people, and we see that in the preamble. Okay? Point 4. The relationship between Section 1, Section 2, and Section 3, and Section 321 forms a constitutional structure. Section 1 identifies our liberties, and we know our liberties are God-given liberties. They're not liberties created by the government. They're not liberties created by men. They're not liberties created by corporations. These are liberties that you inherited as a result of you being a child of God. That makes you the popular sovereignty because Section 2 identifies that you are the popular sovereign and that those delegates, trustees are subject to that sovereignty because when they declared their separation from that sovereign, i.e. the English crown, they pass it on to you. That is your birthright, okay? So Section 1 identifies the liberties, privileges, and that are unimpaired. Section 2 identifies and protects that recognized sovereignty. And Section 3 identifies the conscience, okay? Section 21 prevents those protections from being narrowly confined to specific wording appearing in the constitutional text by way of the enumeration of those rights that you see in the text from Section 1 to Section 21. Okay? Because it said in Section 21 that those enumerated rights should not impair those rights retained by what we call the people. Thus, hold that thought. Thus, Section 1 supplies the right, Section 2 supplies the source of political authority, i.e., popular sovereignty, and Section 3 supplies freedom of conscience. Section 21 protects the continuity, i.e., the continuing existence of the unenumerated liberties. You hear that? Not enumerated rights, but unenumerated rights. Liberties, all right? Once again, not enumerated liberties, but unenumerated liberties, which means those liberties that were not written down. Point 5. The historical lineage extends through the common law tradition. The intellectual ancestry may be viewed as what? The Magna Carta, Article 1, Clause 1, Clause 36, and Clause 39, all protected by the English common law. And what common law case law we use to prove that? Which is what we call wine, Kimmel, art. Okay? Begot, seen, thing. Okay? These were common law that explain the people, the political status of the people, as well as the popular sovereignty that the people originally have, which was adopted by what we call those that didn't have that popular sovereignty, but yet was there to preserve it. Okay? So we see the American constitutionalism is based upon the preservation of the natural right and philosophy that was being examined by the founding fathers such as Benjamin Franklin. Okay? And they understood that these were not their rights because their rights wasn't based upon a retained right, which is a right that's unimpaired, which is because it was inherited by blood, okay? These rights deal with rights that one was given as a result of a process that was satisfied, known as the Naturalization Act, okay? So we see that the natural rights philosophy was exemplified through the American constitutionalism, which resulted in what we call the 14th Amendment on the federal level and New Jersey Constitution on the state level, which involved the set sections which were in question today. Article 1, that involved Section 1, and Section 2, and Section 3, and Section 21 of Article 1, okay? Which by this point, you should have a clear understanding. Under this bill, Section 21 serves as New Jersey's constitutional reminder that liberty is larger than any written list. So our conclusion of today's lesson is that Section 1, Section 2, and 3 establish the core, substantive, and inalienable natural right that God had given us, that was here from here through perpetuity, forever. All right? We just realizing what they are. Section 21 protects against the argument that only enumerated rights exist. Taken together, these provisions support a constitutional structure in which sovereignty originates with what? The popular sovereignty, which is only the people. Liberty precedes government. Constitutional text is interpreted as a protection of rights rather than a limitation upon them. Okay? Let's blow this up a little bit. So New Jersey's Constitution, i.e., we know the Constitution gives capacity in lieu of the interest that they claim to have, which is only based upon preservation of those liberties, rights that were granted from God and not them, okay? We see that in the preamble, okay? Preamble. We, the people of the state of New Jersey, grateful to Almighty God for our freedom, do obtain and establish this Constitution. So they didn't establish the Constitution. We, the people, established the Constitution, okay, for ourselves and our posterity, based upon our retained rights, which are unimpaired and that existed before the enumeration of the said right that we are reading right now. Because we know that the foundational principles of all government that exists was to secure the inherent and inalienable and retained rights of the people, okay? The retained rights, which means those rights that were not listed, okay? Article 1, rights and privileges, okay? Section 21, natural and unalienable rights. All persons by nature are free and independent and have certain natural and inalienable rights, among which are those of enjoying and defending life, liberty, and acquiring and possession and protecting property, and pursuing and obtaining safety and happiness. This is a retained right, not an enumerated right, but a unenumerated right. It was an inherited right that you were born with. It's inalienable. Okay? Section 2. All political powers in the people. All political power is vested in and derived from the people. This is in Section 2. All right, government is instituted for the equal protection and benefit, and they have the right to alter, reform, or abolish in any such manner as they may deem most conducive to the public good. That's the popular sovereignty that we the people have. And then we have Section 3. Freedom of conscience and religion. All persons have the natural and inalienable right that we see in Section 1, protected by Section 2, and exempted by Section 3. To worship Almighty God according to the dictates of their own conscience, and no man shall compel to frequent or support any place of worship that he does not believe to be in the best interest and capacity of the purpose intent of why the preservation was created in the first place. Okay? We see Section 21 is the rule of construction, which prevents narrow interpretation and protects all rights retained by the people, written or unwritten. You hear that? Written or unwritten. Section 21, retention of unenumerated rights. Not enumerated rights, but unenumerated rights. That the enumeration in this Constitution of certain rights should not be construed to deny or disparage other retained by the others retained by the people, which means that the people have unlimited rights that were not exclusively listed in this Constitution. So the effects, okay, of Section 21 prevents the government from claiming rights do not exist just because they do not specifically they're not specifically listed in this Constitution, nor can as well as it protects evolving liberties as society and law grows. Okay, so as society and law evolves modernly, that same protection carries over unimpaired. All right. And we know that this is because of our court system, because the courts are empowered to safeguard these fundamental rights against overreach, and we know that that's through declaratory and injunctive relief. Okay? Come on. Come on. Okay. Purpose. This Constitution, through its principles and provisions, established a government of limited power, bound to protect the inherited and inalienable retained rights of the people. This is Section 1, Section 2, Section 3, and Section 21 of New Jersey's Constitution. Okay? This is what the Constitution is there to ensure that those who are administratively authorized in the capacity as authorized by the Constitution to protect the capacity of the people and the capacity that they have in regards to their substantive and inalienable rights, which the statute preserves. 1 second. Okay, so we see under Article 1, Section 1 of the New Jersey Constitution, which is where our substantive rights come from in lieu of our rights and privileges and immunities, is our capacity as being members of our religious society, which is what we call a corporate capacity. But as members of the church in our corporate capacity, we also have a private capacity that's also protected by the same statute, 16:1-28. In lieu of our interest, which is, as we see in Section 1 of Article 1 of the Egyptian Constitution, which is the right to life, liberty, property, and protection of that life, liberty, and property, which is governed under Title 46, which is our lost and inherited estate, which was preserved by our ancestors. Okay? So 61-28 is our capacity. Title 46 is our interest, and due declaratory and injunctive relief, we can receive a declaratory judgment in lieu of our justifiable controversy that we can present before a court of law in lieu of what we call declaratory and injunctive relief. Because we know that courts interpret the Constitution and statutes, determining rights and duties, and grant appropriate relief. This is called declaratory and injunctive relief. Okay? Declaratory and injunctive relief. How many of those who are there who claim to be or who claim to have the capacity and interest in regards to your natural and inalienable rights that you inherited and that should be unimpaired and that should be protected by the enumerated rights that we have now that are listed, who has put in the footwork to bring such clarity to such existing laws that have not been implemented on our behalf as of yet? Okay? Who has? So it's very important to understand how important this lesson is and that you take these lessons seriously. Okay? To take these lectures and lessons I'm giving you seriously. I hope that those who have logged in today and as well as yesterday will get a fuller picture of the message that I'm bringing to you in regards to popular sovereignty of the people. And the Constitution proves that by the very language of it. And with that, I'm going to greet you as I have always greeted you, and that is the love of our ancestors. With that,